just a continuation from last time about expert opinion, and since most of us are very senior people, and we would be referred cases about so-called judging about whether there is good management of the case or not. We should know about the basic rules, because see, each and every word that we write is going to be sharply seen, screened, and judged again by the eyes of the court, the judicial officer sitting over there. And it has to be a very, very scientific and very objective report, I would say, upfront, and to avoid any element of subjectivity there could have been. So just to start with, what is the importance of an expert opinion? It can see what is the object of the expert opinion and object of the judicial officer. Why are we doing this exercise? The court is there to see whether there is the three elements of medical, four elements rather, of medical negligence that we talk about, whether there has been breach of duty, whether there was direct causation, what was the standard of care, and finally, how much damage did the patient suffer. So similarly, we are going to examine all these four aspects on behalf of the court or on behalf of the applicant, the gynecologist, or whoever doctor there might have been in the case, and see whether what was the standard of care expected by the doctor, was there any breach of that duty of care or the standard of care, and was there any what was the causation or the link between the standard of care and the breach, and was there any damage. Of course, the damage part might not be so much for us to quantify and measure, but it is for the duty of the court. But to see whether was there any damage at all, rather than commenting upon the quantum of damage at all. And not only that, it enhances the credibility and objectivity of the case itself for the accused doctor, the defendant, the respondent doctor. And your expert opinion helps the or assists the court in understanding complex medical concepts and issues, because you are there not only to give your opinion as a board of experts, but also to uh, explain to the court the meaning of certain medical terms, what they mean, and what is your interpretation as experts in that particular medical field.
Dr. Gaurav, your slide are not moving, and make it full screen, sir.
I have done that. Should I don't know. I'll stop sharing and start again. No, this is not what I want. So, is the screen visible now?
But it's not full screen. That's okay. That's all right.
Okay.
No, but it was earlier full screen.
Yeah,
You were
that's
able to sleep. Yeah, it was earlier full screen. Now it is not full screen.
not is not.
No, now it is not full screen. Earlier it was full screen.
Okay. Are the slides moving?
No, we are on the one on
The slide is
importance of
moved.
expert.
Slide is moved.
But Dr. Jain, is it full screen now from your end?
No, you have to
No.
you have to press that pyala niche wala.
I have done that. And
That's okay. We can see it. We can see it.
Okay. Now, are the slides moving now?
No.
No, you move them.
Yeah, I'm moving them now. I'm on the fourth slide. Fifth
No,
slide.
we are not seeing. We are seeing the first slide.
You're on the third slide.
Yeah. Entire screen. Okay, let me do it again. Entire screen पे कर रहा हूँ ना, तो ये okay, and then Okay, I should go to the my slide and then it will be okay. Okay.
Every day is a day of learning.
Yeah, I know. So better now?
Yes.
Definitely.
Yeah,
Yes.
yeah.
Yeah, now it
Absolutely.
is. Now.
Oh, ये दूसरी खुल गई. That was my next session. 3 days. Okay, now.
Yes, it is good.
This
Yeah.
is okay.
Okay, sorry for the fox pass. So that was the importance and parts of a report on expert opinion. So there are three parts, like, every medical legal or every legal document that we prepare, which has got anything medical in it, and the introduction part, which has got all the preliminary data of the case, the patient details, about the doctor, the place of examination, all those things. The second part of the report is the body of the report that we say, and it includes the observation or examination findings that have been recorded by the expert doctors. And the third part is the opinion or inferences part drawn from the observations, which is the concluding part of the opinion. And then what are the components of a report on expert opinion? I'll talk about this in detail in 8 points. What should a good report include? The observations from the report, how should we record them? The summary of the important points, because the observations can sometimes go up to 2-3 pages depending upon the case. So we have to draw certain important summary of those observations. Then when commenting on the opinion of other experts, see, sometimes it does happen, although it might not happen in our scenarios that we are likely to encounter, but in government hospital scenarios, it does happen that one expert might not agree with the opinion of two other experts, so they can give a separate opinion. The exact opinion, the law regarding the opinion that we have to be aware of, the role of an expert, and the pitfalls in an expert opinion. So what should a good report include? We start with the title page first. No, it should mandatorily have all these things, like the date of the report, the time of examination of the records or the person, if there is any, the identity of both the parties, the complainant and the defendant doctor, the full name and date of birth of the complainant, especially if the complainant or the person on the behalf of the complainant happens to be a minor, the patient, especially the party making the request or the application, that is the defendant doctor, the nature of the report, whether it is about giving expert opinion into the nature of treatment or in the management of the case. All the report pages should be numbered, and it should have short numbered paragraphs, not very lengthy sentences, and there should be appropriate subheadings one can create. I mentioned there are three parts: the preliminary part, the body, the observations, that is, and the inference part, the opinion. So you can have subheadings, not an issue regarding that. Then that is expert's personal details should be there: the name, the current post held by you, the summary of the previous experiences. For example, 32 years of experience in obstetrics and gynecology. Your medical, you don't need to mention all the places that you visited in the past or worked. Your medical council registration number. There was a case wherein the doctor expert did not mention the registration number, and the patient said that by law every report produced by a doctor should have the registration number, as rightly pointed out by the previous speaker. So it could be a fraud doctor, he said. So you should have your registration number in each of such documents as well, not only your prescriptions, whether you hold a current license to practice. See, LTP is a proposed law already into force, although it has not been rolled out actually by the National Medical Council. But so we are going to have the LTP along with, in addition to the registration number. So statement of opinion, you've been asked to provide and details of your relevant knowledge and experience in the field. For example, received an application regarding by so and so. In the end of the presentation, I'll show you 4 slides giving a sample report, actually what it should look like. So you should have the details of your knowledge and experience, and the statement as if receive application regarding whether there was any regarding the management of the case. That should be that is enough to mention. The lists are textbook and references that you have relied upon in reaching your opinion. This is a often ignored part by the expert doctors. They do not know about it. They think it's too immature to maybe refer to books and write their names. But this is something very, very legal the courts call it treatise, these textbooks and references. And it is, I would lay down a special emphasis that you mention at least the names of very, some important Indian textbooks, and maybe in addition to that, certain foreign textbooks in the subject, and list out the special, if you can, certain pages in it. Report should have a chronological order and summary of the relevant evidence, that is giving exact dates of incidents and important points of OPD, admission, surgery, post-op, discharge, all these things wherever possible. May refer to important parts of the records, quoting relevant entries verbatim, if possible, identifying it as a direct quote, for example, by the use of italics. Many court judgments have important paras in their judgment, which are written in italics and in direct quotes. So we should also have, because it highlights that important part that the court is going to see, and it could be quoted verbatim from the records or verbatim from some textbooks as well. Then identifying disputed facts and stating the sources of the information set out. For example, history given on admission to hospital on 1 February, but the OPD paper says, as per the patient, the complaint, it is about 1 February 2024, but the OPD paper says it is about 28th December 2023. So this was highlight the contradictory statements, and which might later on reflect in the opinion given by the experts. Explain what is relevant, the technical terms that are there in the report, and so that the court can easily understand them. See, what happens is the court is not, you might say they do not know an M about medicine, and how can they judge about whether the management given by the doctor has been good or not? Are very common, the first thought that we have. But think of it from our end. If the court does not understand anything, they do not have time or the knowledge or the manpower to every time go and Google it, and they might simply ignore it, which may go against the favor of the applicant respondent doctor. Review the evidence for a sufficient period of time before and after the incident or the period of alleged negligence, to put the events in context and highlight other relevant features of the history. For example, there may have been certain complaint, and whenever we are examining, we are not only examining this is, although kind of a very controversial statement of fact to make, we are not examining only the management papers, the medical records by the doctors. We are also examining the complaint by the complainant in the case. So we have to match whatever the complaint is matching with the facts in the medical papers or not. And we have to highlight, we might not need to point out each and every point in if them on an average, there might be 20 or 30 complaints in a complaint by the patient's family. We might not need to comment on each of the 20 points, but the important ones we may need to summarize and then comment upon them. For example, if they match or they do not match with those facts given in the medical records. Then record the relevant positive and negative findings. We know the importance of these things. For example, no history of bleeding, no history of trauma. Maintain a clear distinction between the history given, the examination findings of as per the medical records, and your interpretation of those findings. It is always wise to summarize the observations. Focus on the significance of the history for the patient's everyday life. For example, let's say the pregnant woman was under stress, physical stress or mental stress, for a prolonged period of time, for which she was advised to take rest and she did not. And if it comes somewhere in the complaints or as per medical records, then it may go against the patient. So we have to pick up each and every finding in the patient's everyday life wherever possible. Give time scales, observations from the report. How to record the observations from the report. Give time-wise time scale or probable improvement or deterioration in the treatment options available to the patient that have been notified by the team of doctors. Refer back to the complaint. Whenever I prepare, I'm sharing this from personal experience. I have a complaint with me, and I have got medical records which are into 50 or 60 papers on an average. I might have to look at the complaints at least 10 or 20 times, each one of them, and then try to match with those present in the records. There might be answers available, there might not be answers available, and all the answers might not be available in the OPD sheet, the case records prepared by the doctor. They might be available somewhere else. So we might have to look at them again and again. Refer back to the complaint if appropriate to ensure that all relevant matters have been addressed by the team of doctors. Only comment on matters within your expertise. If there is something of another specialty, okay, refer them, but then please do not comment upon them. It is not our field of expertise. Comment on each question or allegation of negligence separately, quoting the question or allegation wherever possible. When the question or appears to repeat or overlap with another or seems misdirected, explain why and refer to other relevant paragraphs in the medical records. Justify the conclusions reached by the reference to the evidence in the case, your specialist knowledge and published references you relied on. These not only help to justify the treatment that the defendant doctor has administered to the patient, but also gives credibility to your opinion in the eyes of the judicial officer in the court. Summarize the areas of agreement and disagreement, if any, with other experts. Point to the evidence supporting or undermining views given. Remain focused on the facts of the particular case. If there are certain complaints that you think while examining the medical records, you might think that the patient has not made a complaint which might should have. Obviously, avoid commenting upon that. Just focus on sometimes the complaints that the patient is making is not about management of the case as much as about the lack of communication or some ego issue that the patient might be harboring against the team of doctors that is there in the complaint. So let us be focused only on the particular complaints and not comment upon each and every aspect. Distinguish between question of fact and of opinion. We have to avoid terms like may have been. The conjectural part has to be avoided as far as possible. It seems to be avoid adjectives as much as possible, especially in the opinion part and while summarizing the observations in a small paragraph. Distinguish clearly between known facts and assumptions made. Then finally, the opinion part, return to the issues you have been asked to consider and or pleadings, that is the requests made by the, at the end of the complaint. Sometimes if it is legally drafted, the patients have a prayer that is the end of the complaint in which they are making pleadings to the court to give them justice. So please focus on them to make sure that the opinion has been given on all relevant matters with proper attention to the legal test, that is the Boehm's test that is applied to. The report should not be value laden. What does it mean? That means something influenced by personal opinion or strong views that we strongly feel. If the board of experts is using adjectives like these, or there is gross, or there is none whatsoever, these kind of adjectives or paras should be avoided as far as possible. The report should not be judgmental. This was absolutely right treatment given to the patient, or absolutely unjustified. Things like these should be avoided. So judgmental is something that tends to make overly critical moral judgments that the patient did not do it right and so was wrong, or that he should have behaved nicely or more appropriately, or fault finding, making negative assumptions about somebody. That is what is judgmental, and things like that should be avoided. And conclude with a statement of truth. It is kind of a legal statement. That is a statement that confirms the facts in a document to the best knowledge of the person making the statement. That is the board of doctors, board of experts. For example, in civil proceedings, a statement of truth in some documents, such as witness of statements, expert reports and statements of case, it should not be conjectural. That is, so the such kind of things have to be written, and a statement of truth has to be provided at the end of the opinion. What is the law regarding all these? You must be honest and trustworthy when giving evidence. Make sure that any evidence you give or documents you write or sign are not false or misleading. I remember a case, it happened only a couple of years ago, where there were 5 expert opinions and the total number of doctors who opined on the case were 17. Can you imagine? And what happened in the case? All the 5 expert opinions and the opinion of 17 doctors were rejected by the court, because all the opinions were silent about one aspect, and that is why the hell was there delay in looking after the patient by the doctor, and why the hell was there delay in transferring. All the 5 reports of experts were silent on this fact, and the court, I should not say rightly or whatever, lambasted all the expert opinions for being, grossly in favor of the respondent doctor. So you should recognize and work within the limits of your competence and abide by the guidance when giving evidence in non-medical scenarios. What are the laws behind this? I'll just, for the sake of time, list out the 4 important ones. And if you have time, take a please screenshot or click this, and I'll just read out important points. Just one line from each of these 4 judgments. CP Srikumar versus Ramanujan from Supreme Court, Sethuraman Subramaniam Iyer judgment from National Commission, Kiranbala Rao judgment from National Commission, Shambhala Bai judgment from High Court of Karnataka. And as far as criminal law is concerned, Jacob Matthews State of Punjab, I am not going to talk about it. We are all been, apprised of this quite a number of times. So as far as Shri Kumar, see, all these 4 judgments of the civil court and one of the criminal court are regarding expert opinions. Okay, that is why I've taken this up in this session. The Supreme Court said the onus to prove medical negligence lies largely on the claimant, that is the patient, and that this onus can be discharged by leading cogent evidence as far as cogent evidence as far as expert opinion is concerned. In Sethuram Subramaniam Iyer judgment, the National Commission said the complainant did not requisition the services of any expert to support his allegations, so it would have helped him had he done it. In the absence of any expert evidence on behalf of the complainant, the State Commission was right in relying upon the affidavits filed by 4 doctors on behalf of the respondents and in holding that there was no negligence on their part. So there are very, very categorical statements given by honorable judicial officers. In Kiranbala Raut judgment of the National Commission said medical negligence must be established and not presumed in the absence of an expert evidence on behalf of the complainant, whatever, And lastly, in Shamabala by judgment of the High Court of Karnataka, it said that I have also taken note of the judgment rendered by Apex Court in the case of Martin D'Souza. The investigating officer, before proceeding against the Doctors for Rash and Negligent Act, should obtain an independent, competent medical opinion. Although this part of the judgment has been declared against the laws of justice, but the other parts still hold valid. Jacob Matthews judgment, we all know the investigating officer should, before proceeding against but this is only for the criminal cases, accused of negligent omission, obtain an independent, competent medical opinion from expert doctors. Do you know who this guy is on your screen on the right? The left is obviously me. Anybody?
Jacob Matthews.
Jacob
Yeah.
Matthews.
So had a chance to meet him at Jaipur 2 weeks ago in a medico-legal summit, and very humble guy, but responsible for saving the lives of countless doctors in this country, especially for criminal prosecution from going to jail. Very, very humble guy. He practices in Kochi, Kerala.
You shared this picture in the group also.
Yes.
Yeah. So lastly, the role of an expert. Expert comes to court to pass on benefits of his or her experience in the case of, this is from a judgment outside, but look at the wordings. These judgments often tend to be used in our country, in our judgments in their countries. Agreed that the court said an expert is called by a particular party, presumably because the conclusion of an expert using his or her expertise is in favor of the line of argument of the particular party. The court also said, but that does not absolve the expert from providing the court with an objective and unbiased opinion based on his or expert as is possible. An expert is not a hired gun. Obviously, the court, whenever such an expert opinion goes in front of the eyes of the judicial officer, they know the doctor might have paid money, or if not, they might have influenced. They might be their colleagues, might be their teachers, might be their juniors, whom they might have directed to prepare their expert opinion in their favor. They know this very well, but despite that, they accept or they might not accept the opinion of the experts. So, expert witnesses provide objective and unbiased opinion based on their expertise. They assist the court in understanding complex medical concepts and issues involved in the case. Expert witnesses analyze the facts, review medical records, and determine whether the healthcare provider met the standard of care or not. Because that is what we are doing, the job of the court in a way. That is why we have to be very, very vigilant. It is not a joke. They offer insights into whether the defendant breached their duty of care towards the patient. Expert witnesses can explain medical terminology and procedure to the judge and jury in a clear and understandable manner. This is especially valid in a summary trial as of consumer courts, because doctors do not get a chance to explain their point of view. The trial is all on paper, and that too summarily tried. They do not give you all the stages that are there in a civil court, like stage of pleading, stage of evidence, stage of arguments. There is only two stages. One is the entire stage on paper, so called affidavits. It will include everything, including the evidence. And lastly, a single day given for arguments in the case. Even if you want to cross examine the patient, sometimes the most often the court say, okay, give your questions on paper, the patient will answer them on through a questionnaire, and the vice versa. The testimony can help causation between the doctor section and the patient's harm. And lastly, the pitfalls. An expert who oversteps their responsibilities and ignores the principle of law risks damaging their reputation and integrity. Honestly, the reputation of the gynae forum might be there, the Foxy or any professional bodies might be at stake in front of the eyes of court. Other important points to remember include ensuring complete objectivity, and the case must not be discussed with colleagues to maintain privacy and confidentiality. What could be the disadvantages of an expert opinion? It may cause enmity against medical fraternity. For example, the State Medical Council gives anything contrary to the expectations of the doctor. It may cause delay in disposal of medical negligence cases. Some state medical council may take as much as 2 years, to give their final opinion in the case, even if directed by the court to do so. Due to biased medical opinion, adverse comments by the courts, it may cause distrust among the public. I'll skip this. I'll just to show you that on the website of Uttarakhand government, there are certain duties of formation of expert committee given over there. But I'll come to the sample report, the concluding part of my presentation. What an expert opinion should actually look like. We as forensic people or people who've been in this field for a long time, this is what we routinely do, and you must keep this as a sample or understand what it actually should look like. So I've divided this into 4 slides. To start with, it should be always on the letterhead of the organization. It should have the report number, which should be chronologically numbered in maybe a Excel sheet, which can be kept with the records of the office of that professional body, or maybe you could maintain it in a register kept with the office of the organization. It should then timed. I forgot to miss the time over here. The report should be titled expert opinion under, there are debatable whether you want to mention under section 45 of the Indian Evidence Act, but it shows a professional approach to the report. We always, as forensic people, whatever the nature of the report might be, always give it under 45 section 45 of the Indian Evidence Act, because that is where the law is applied as far as the judiciary is concerned. So we can start the report by mentioning that the Secretary of Delhi Gynae Forum has received an application dated so and so date, along with copies of complaint received against her and the medical records, numbering a total of 66 number of papers from Dr. DEF with qualifications of MBBS MD in specializing in obstetrics and gynecology, with the request to give expert opinion into the treatment of the patient, namely so and so. See, it is always wise to name the patient here. It shows compassion, and obviously legally it is tenable as per the medical record submitted. As per the papers, the matter is in court. In the case, there is nothing wrong in giving an expert opinion by a board of a professional body. even if the matter is sub judice. You can go ahead and do it under Section 45 on the Indian Evidence Act. So in the case of patient versus Dr. D and F and others, case number so and so, Delhi Consumer Disputes Redressal Commission, Central District, New Delhi, etc. Next para, the secretary of the organization has formed a panel of experts. This part is important. Under the chairmanship of Dr. So and so, it could be the secretary or it could be any other doctor of that organization to give opinion into the case as per details of the panel below. Number 1, 2, 3, containing the names of the doctors, their complete qualifications. So this is mandatory, please. Their complete designation, their branch of specialization with numbers of experience. This is not mandatory, but obviously it shows that yes, you are all senior people with registration number, which is of course mandatory, and the name of the medical council of all the experts, 3, 4, 5, whatever. Then it should be followed by the panel of experts to screen the medical records of the patient so and so, again on so and so date at the office of the Delhi Gynae Forum. For example, the medical records consist of, need not mention the number of each and every category, just summarize them so that it shows to the court what all you have screened. OPD sheets, admission paper, consent for admission to hospital, pre-anesthesia notes, consent for surgery, consent for anesthesia, surgical notes, post-surgical care notes, ICU management papers, reports of investigations, ultrasound report, X-ray report, MRI report, nursing records, input-output records, high-risk counseling sheet, discharge summary and advice. The panel of doctors has made the following observations. So now you come to the observations part, that is the body of the report actually. This all was the preliminary data. Okay, so now you should number your paragraphs or the entire report as such, and then put the summary of all the observations from the case records in chronologically numbered paragraphs 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. They could be running into 1 page, 2 page, 3 pages or whatever, but then just to summarize the important points, you can again include a summary of observations differently entitled, such as A, B, C, in very short sentences, the important ones only. You might ignore this part, and if you think it proper, please go ahead with it. Then finally, the opinion under Section 45 Indian Evidence Act, it should be written in such manner. The panel of experts has applied Boehm's test. It is important to mention Boehm's test because this is what the judiciary is going to do, and this is what you are going to do on behalf of the applicant doctor, the defendant, the accused, and also on the behalf of the court. So the panel of experts is applied, and what is Boehm's test in one single line? It is just a standard of care that the applicant doctor is followed or not, as per the practice in the community and as per other doctors would have followed. That is what is Boehm's test. To the duty of care and management of the entire case offered to the patient and is of the considered opinion. It does not has to be the exact language I am mentioning. It is approximately this is what should be done. Is of the considered opinion that the treatment of the patient was conducted or not conducted as per accepted medical practice in the given situation and as per the guidelines of management. That this part is very important. As per the guidelines of management in accordance with standard textbooks. So you have written two parts. One is as per accepted medical practice, and second is as per accepted standard textbooks in the subject. And please provide the references below. You please see at the screen below, there are references. Textbooks are always preferred over journal articles. Indian textbooks always preferred over foreign textbooks. Indian journal articles preferred over foreign journal articles. Please mention conflict of interest none, sign, write, and stamp it. So this was all from my end. I'll be happy to take questions.